new faces that were not here last time, so I may not know who's appearing for. If they could just and jury for the petitioner.
Keep Rotich. Oh. For the first respondent.
Can you deal with petitioners first?
For the first and the third respondents.
My name is Kuyoni.
I am present for the second respondent to the Speaker of the National Assembly.
Good afternoon, my name is Karanja. I hold brief for Mr. Edwin Mukele and Professor Tobo Jenasenia Kanto for the fourth respondent. I equally hold brief for Ms. Tanji for the fifth respondent.
If it pleases my Lord, my name is Noura and I appear for the ninth respondent.
Yes.
By a notice of motion dated 1st of October 2025, the appellant, who is also the petitioner, raised that this bench, comprising Gola, Mrema, and Gambi JJ, do recuse themselves from further hearing on or determination of any aspect of these proceedings. The applicant further seeks to have this matter placed before the Honorable Chief Justice for directions of Joseph Enoch Aura, sworn on 2nd of October 2025. The applicant contends that he has been subjected to discrimination by the bench. He particularly contends that the present petition has been irrationally isolated from the consolidated petitions, notwithstanding that it raises substantial similar issues as those in the consolidated petitions. According to him, such isolation amounts to a violation of Article 27, Sub-Article 4 of the Constitution. The applicant emphasizes that it is necessary to have the present petition heard and determined together with the other consolidated petitions, particularly in relation to the issue of an expended bench. He is therefore apprehensive that, owing to the apparent bias of this bench, he will not receive justice in these proceedings. He has cited Supreme Court decisions which we have noted interpreted by a reasonable and informed observer as an attempt for the court to deliberately sideline him and to prop his petition within the confines of the res judicata technicality.
The accused themselves are well settled in law and firmly anchored in jurisprudence. This bench has previously had occasion to pronounce itself on the subject in constitutional petition number E522. In that ruling, we were emphatic that the test for recusal is objective and rests on whether a reasonable and informed observer viewing the matter in its proper context would apprehend bias. We further emphasize that recusal is not to be invoked lightly, but only where circumstances disclose a real likelihood of bias, or where justice would not be seen to be done if the judge were to continue presiding over the matter. We reiterate that position, and we have highlighted the specific paragraphs where the issue was raised. Now, the grounds previously advanced for seeking the recusal of this bench were premised on alleged undisclosed relationships with certain parties to the petitions, which, it was claimed, might have influenced the court to convene and sit on a Saturday with the intention of assisting one party in the proceedings. We have carefully considered the grounds of recusal raised in the present application against those that were canvassed in the earlier petition. With respect, we are unable to agree with the contention that the present application is barred by the doctrine of res judicata, noting that the grounds then and those now advanced are materially distinct. Accordingly, we shall proceed to consider and determine the present application and its merits. And we find it apt to begin by referring to the decision in Dobbs versus Tridios Bank, where the court stated and emphasized on the importance of a judge to resist the temptation to recuse himself simply because it would be more comfortable or convenient to do so. That decision is quoted quite extensively. I do not intend to quote the entire portion of it. In the present matter, the applicant pleads bias on the part of this bench. To address this contention, we turn to the New Zealand Supreme Court decision in Saxmere Company Limited versus Woolboard Company Limited, where the court again articulated the applicable standard for recusal on grounds of bias. The court held that the test is one of real and not remote possibility rather than probability, and is to be applied through a two-stage inquiry. So the judge must consider first what it is that might possibly lead to a reasonable apprehension by a fully informed observer that the judge might decide the case other than on its merits, and the secondly, whether there is a logical and sufficient connection between those circumstances and that apprehension. Insofar as concerns the informed and fair-minded observer, in whose eyes the potential for bias must be determined, the Court of Appeal in the Gachagua and 5 others versus Maingi and 5 others and 80 others, the Court of Appeal was succinct in restating the applicable threshold. A similar position was echoed in Hab versus His Royal Highness Prince Abdulaziz bin Fahd, where the Court of Appeal of England and Wales emphasized 2 critical points. First, the opinion of the notional informed and fair-minded observer is not to be conflated with that of the litigant, considering that most litigants are inclined to resist anything they perceive as jeopardizing their prospects of success, even where such perceptions are not objectively founded. The court also emphasized that the informed and fair-minded observer is to be treated as knowing all the relevant circumstances and not merely those that are publicly available. We do not wish to again quote the entire, that is a page or 2 of that whole determination. Guided by the foregoing authorities, the pivotal issue for determination is whether, in view of the matters advanced by the applicant in this present application, a fair-minded and fully informed observer, one acquainted with all the relevant circumstances, would reasonably perceive this bench as having exhibited bias against the applicant so as to justify recusal. The applicant contends that this bench directed that his petition be heard in isolation, segregated from the other petitions. What he fails to disclose, however, is that on the 23rd of January 2025, this very bench issued express directions consolidating this petition with the other related petitions. The record is clear and confirms the following directions of the court. Direction number 3, that all petitions before the court, that is under cohort 1, cohort 2, and the petitions being today mentioned for the first time, the court went on to enumerate those petitions, including Nairobi petition number E586 of 2024, which is the current petition, are hereby reconsolidated into one petition. Petition number E565 of 2024 shall be the lead file. All filings henceforth shall be made in this file. How then did we arrive at the present situation where a petition that had previously been consolidated is now being heard separately? The answer lies in the record of the 29th of May 2025. Contrary to the applicant's assertions, and in what we consider a demonstration of bad faith and lack of candor to this court, it was the applicant himself, through learned counsel Mr. Harrison Kimonjui, who sought and obtained leave for the petition to be consolidated and thereafter mentioned separately from the other consolidated petitions. Council expressly submitted that the instant petition raised unique issues requiring expeditious determination by an expanded bench of judges. It was in recognition of this submission that the court reviewed its prior directions. The court concluded that the uniqueness of the petition justified deviation from the general rule and that fairness demanded that the petitioner be afforded an opportunity to prosecute his case without being held in abeyance pending the outcome of cohorts 1 and 2. These directions were not concealed. They were openly given in session, and the rationale for this was explained. For the avoidance of doubt, this bench directed as follows, we quote, "In order to allow the petitioner room and the latitude to fully ventilate his case, and noting that the first interested party has indicated that he will not be participating in this petition, and further noting the previous directions issued by this bench to the effect that petitions not consolidated in the first and second cohort would await the determination of the consolidated petitions in cohort 1 and 2, we review these directions in view of the uniqueness of this petition and allow it to run on its own." Close of quote. The segregation of the petition was not a unilateral act of the court, but rather a direct consequence of the applicant's own request. From a case management perspective, had the court not allowed the petition to proceed separately, it may very well have fallen squarely within the category of petitions required to await the outcome of cohorts 1 and 2. It is therefore our considered view that the fair-minded and informed observer, one who is appraised of the full procedural history, the rationale for the directions issued, and the applicant's active role in seeking deconsolidation would not apprehend bias, mainly because the petition is now proceeding separately.
Accordingly, therefore, we find apprehension of bias on the part of this bench. The application dated 1st of October 2025 is therefore dismissed. Parties shall bear their own costs. That is the order of the court.
My Lord, my lady, I had previously prayed for on the 29th of May 2025 for the tied certified proceedings with a view to appeal against that very decision, which has been referenced in your ruling. To date, I have not received a communication from the DR, although it's administrative, that's part of the record. I rehash the same. And therefore, we pray so far in relation to these proceedings with a view to appealing against the decision. Now, the last issue that I'd like to bring to the court's attention is that in our plea for the consolidation on the 29th of May 2025, we had thought that this petition be heard together, not separately, together with. And I'm not asking that you revisit your ruling, which you rendered right now. Now it has come to attention that you have a mention for the other petitions, December 16th. We will humbly request that you give us a mention on that same day, for good order. Thank you.
Is your client's application dated the 20th of May 2025, which we are prepared to give direction. So we're wondering on the 16th, what is it that you want? Yes.
In tandem with Our Ladyship's direction, we had indicated to Our Ladyship that we had sought before her for an expanded bench.
Yes.
And she had indicated, as a record will bear, as part of the expertise, make your application in the presence of the other counsel for the other consolidated petitions, so that this bench can consider the same, and then that decision can be made in the light of everyone's presence in the plea. So that, my Lord, just to answer you, with tremendous respect, if this particular plea, I don't know if I've lost you, Judge.
No, proceed.
That application cannot, in my humble submission, proceed absent compliance with her leadership, the Honorable the Chief Justice, direction to us that we make it before you in the presence of everybody else, whose decision, that is the bench decision, would implicate their petitions. That is the sole intention for that purpose. So that then our application, with tremendous respect, cannot be disposed of in the absence of everybody else that is involved in the other petitions. Last,
Now,
our leadership.
but,
May I say?
I mean, just hold a bit.
Yes.
Is it not part of the motion dated 20th of May, the issue of the expanded bench?
Yes.
Isn't it?
Yes.
Yes. So, if we deal with the application dated 20th of May, we will have taken care of the direction by the CJ. Because the CJ is saying, make your application for the expanded bench before your colleagues. And the issue of expanded bench is contained in your application dated 20th of May. So in essence, if you hear this one interpreted, then you will not comply with those directions.
But absent the other people? Absent the other
We
people?
will give directions. Today we give you directions so that everybody who wants to participate in this application participates.
Oh, I'm sorry, my Lord, I misapprehended what you said. But to answer your query, was based on why do you want to be there on the 16th?
Yes.
And I say, so that that particular issue you've addressed, my Lord, and thank you very much. I would then table your lordships and my lady at that time. So that then the involvement of everybody that is implicated or somehow would be implicated in your decision, in my petition, then it would be fully participatory. And I'm saying that as I close, my Lord, please don't be patient. With respect. So that your lordship, sorry, so that your lordship, we save judicial time. We don't have a replication of representations not for. That's the sole reason.
Okay. So if I get your reading alongside the others so that between now and then you serve all the other parties with this application, then we take directions on that bench.
I've already spoken. Everybody is fully aware.
Very good.
So that your lordship then, because you asked me, why do you want to be included on the 16th?
Yes.
Why do we include the part? It's for that purpose. So that everybody comes on the 16th fully aware and like the fact the 20th of May application sought by Mr. Joseph Enokaura to have the expanded bench as per our leadership's direction is the sole issue that we want to take directions on.
And those are directions we can give now, and we serve on the rest of the parties. We don't need to wait up to 16.
I'll be happy. It's only that you ask me why I want to be president.
Exactly. So we will give directions on the application. Here we will serve all parties who other related petitions. So the motion directions we haven't confirmed service of any who is interested in pursuing or taking part in the Yes.
With you.
Let me.
Where we were late last year and early this year. We were opposed, my lord, to mentioning that unless this court sets aside its directions, setting aside this matter to run its own course separate from the rest.
Now, Council, your name? Will not be mentioned on the 16th. Because the timelines we have given will go way past 16th. And we have said we will not give room for parties to highlight. You comply, file your submissions, then we were going to give you a ruling date today. So we are of the view as a bench that the matter, there's no point. Because we have to determine this application path. Okay.
My four colleagues here will highlight even now.
Even submissions.
Yes, we had filed submissions.
Are you sure there's no any other party in the other petition which may be interested in this application? Because that is what we want to avoid. We are first with an application to review and to set aside proceedings. That's why we are.
My lord, I think that would be because those other parties appear in this very same petition.
By Mr. Kinjui,
yes,
which is the determination, and you have given leeway for parties who are interested in pursuing that application to participate in it.
Yes.
So I think it will only be fair that we communicate to our clients the position so that we can get instruction on whether to file responses and submissions. So I think it will be in order that we can file those amendments as opposed to pushing, highlighting now without the benefit of all these other parties who would be interested in that application.
Mr. Kiprotich, I do not think.
20?
27 of January.
27th of January.
27th of January. Yeah, for highlighting.
This is going to be for highlighting submissions.
Yes. Now, Mr. Kinjui.
Yes, Your Worship.
The reason we were trying to, I will be involved in the Court of Appeal interviews, and you know how intense they are. So that I'm a bit apprehensive if we fix it for highlighting and with the necessity of me participating. I may make it, depending on how that day will be.
Actually, Your Lordship, I wish you would make it. We need your, and Your Lordships. I mean, really, we need the minds will gusto in the Court of Appeal, like yours.
Okay, it's okay. Let's pray for the best.
Thank you. My Lord and my Lady, the 21st to the 6th of January is excluded time.
Late February?
Yeah.
Meet?
That is much better.
In the meantime, you appeal.
So it's like virtual. Is it past 2:30?
Do you do it virtually or here?
2:30.
I'll participate virtually.
The highlighting will be done virtually at 2:30.
I'm sorry, I don't want to vex you, but I thought it's far much more easier when we meet up in court.
It is not just about you and your client. We are juggling so many matters and so many issues that we had actually thought that there would be no need for highlighting. You have satisfied us and we have allowed you to highlight. We will do highlighting online on 26th February 2026 at 2:30 p.m.
The reason I was saying so, my board, is that occasionally, I'm not saying always, we have problems with
Well, if there's a problem, the matter will be adjourned, but we will proceed virtually at 2:30 on 26th of February 2026. This is motion, Mr. Teddy. This one. In the we'll go through these directions again. Yes. So these are the directions which we have made. That the respondents to file their responses to the application dated 20th of May 2025 within 14 days. The applicant may respond together with submissions within 14 days of the receipt of the respondent's responses, and then the respondent shall also file their submissions within 14 days of the receipt of the applicant's submissions. The submissions shall be highlighted on 26th of February 2026 virtually at 2:30 p.m. In the meantime, leave to appeal the decision in the notice of motion dated 1st of October 2025 is granted, and typed and certified copies of proceedings shall be availed to the applicant. These directions will be uploaded on the CTS for clarity. That's all.